A federal court just ruled that your concealed carry permit might not protect you anymore in over a dozen states. And if you're planning to travel with your firearm in 2026, there are 5 new legal landmines that could turn a simple road trip into a felony charge. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal isn't being covered by mainstream news. And most gun owners won't hear about these changes until it's too late. Hit that subscribe button right now so you don't miss critical updates that could literally keep you out of prison. Seriously, do it now. I'll wait. All right, let's get into this. 2026 has already brought some massive changes to gun laws. And if you carry concealed, you need to know about every single one of them. I'm going to break down 5 major changes that affect you directly, starting with the one that's causing the most confusion right now. First thing, let's talk about the interstate reciprocity situation that just got turned upside down. Here's what happened. In late 2025, a federal appeals court made a ruling that is now affecting how states recognize each other's concealed carry permits. Before this ruling, if you had a permit from a state like Florida or Texas, you could carry in about 30 to 35 other states depending on reciprocity agreements. Pretty straightforward, right? Well, not anymore. The court said that states have more authority to set their own standards for recognizing out-of-state permits. What this means for you is simple, but serious. Several states, including New Jersey, Maryland, and California, have already announced they're tightening their reciprocity rules starting in March 2026. New Jersey, for example, is now saying they'll only recognize permits from states that have training requirements equal to or stricter than theirs. And their requirements are pretty intense. We're talking 16 hours of classroom training plus live fire qualification. So if your home state only requires 4 hours of training, or maybe no training at all, your permit might be worthless the moment you cross into New Jersey. Here's the part that shocked me when I dug into this. Maryland is taking it even further. They're implementing a digital verification system where officers can instantly check if your specific permit is valid in their state during a traffic stop. And get this, the burden of proof is on you. If their system says your permit isn't recognized and you're carrying anyway, you're getting arrested on the spot. No grace period, no warnings, just handcuffs. Let me break this down with a real scenario. Imagine you're driving from Pennsylvania to visit family in North Carolina. You've done this trip a dozen times with your concealed carry. But now, if you pass through Maryland on Interstate 95 and you haven't checked the updated reciprocity list, you could be committing a felony without even knowing it. Maryland doesn't play around either. Illegal concealed carry in their state is a minimum 1-year sentence, and that's if you have no prior record. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation, and always check current state laws before traveling with a firearm. So what do you do about this? 3 things. Number 1, check the reciprocity status of every state you'll drive through before any trip. And I mean every single state, not just your destination. Number 2, consider getting multiple state permits. Utah and Arizona permits are still widely recognized and relatively easy to obtain, even if you're not a resident. Having backup permits gives you more coverage. Number 3, know your transport laws. If you can't legally carry concealed in a state, you need to know exactly how to legally transport your firearm through that state. Usually that means unloaded, locked in a case, separate from ammunition, and stored in an area not readily accessible like your trunk. But every state has slightly different rules, so verify before you go. If you're finding this helpful so far, imagine what you'll learn in my next video where I'm covering the exact 5 words you should say when police ask if you're carrying during a traffic stop. This phrase has been vetted by 3 different attorneys and it protects your rights while keeping the interaction calm. You don't want to miss that video. Hit subscribe right now so it pops up in your feed the second it drops. Second major change. Let's talk about sensitive places restrictions, because this is where things get really complicated really fast. The Supreme Court's Bruen decision in 2022 said you have a right to carry outside your home, but it also said the government can restrict guns in certain sensitive places. Well, states have been testing exactly how far they can push that sensitive places definition. And in 2026, we're seeing the results. New York just expanded their sensitive places list in January. We're not just talking about courthouses and schools anymore. Now they've added all public parks, all public transit, including subways and buses, any place that serves alcohol even if you're not drinking, all healthcare facilities, including your doctor's office, and here's the kicker, any private property unless the owner posts a sign explicitly allowing firearms. Let me repeat that last one because it's bananas. In New York, you now have to assume every private business prohibits concealed carry unless you see a sign saying guns are welcome. It's guilty until proven innocent, basically. But wait, there's something even more important about this. Other states are watching New York's experiment closely. California, Hawaii, and Illinois have all introduced similar bills in their state legislatures this year. If those pass, you could see a domino effect where blue states across the country adopt these expanded sensitive places restrictions. Here's what most people get wrong about this. They think, well, I'll just ignore those signs. It's just a misdemeanor trespass at worst, right? Wrong. In these states, carrying in a prohibited sensitive place isn't trespass. It's a weapons violation. In New York, it's a Class E felony. That's up to 4 years in prison, and you permanently lose your gun rights forever. One mistake and your Second Amendment rights are gone for life. Here's a hypothetical example to explain this. Let's say you're in Rochester, New York. You stop at a coffee shop that happens to serve beer and wine even though it's 10 in the morning and nobody's drinking alcohol. You're carrying concealed. You don't see any no-gun signs. You think you're fine. But under the new law, that establishment serves alcohol, which makes it a sensitive place. And you just committed a felony the moment you walked through the door. Nobody told you. There was no warning. But ignorance of the law is not a defense. You're looking at years in prison and losing your rights permanently. This is the part that really bothers me. These laws are designed to trap honest gun owners who are trying to follow the rules, but can't possibly know every single restriction without carrying around a law book. Hey, here's a crazy stat. Only 14% of people watching right now are subscribed. That means 86% of you are at risk of missing critical legal updates like this that could save you from a felony charge. Don't be in that 86%. Hit that subscribe button and join the community of informed gun owners who stay ahead of these changes. Third thing you need to know about. Magazine capacity restrictions are spreading and the penalties are getting harsher. Colorado just implemented a new law in January 2026 that drops their magazine limit from 15 rounds down to 10 rounds. But here's where it gets interesting. It's not just about buying new magazines. If you already own 15-round magazines, you now have until June 2026 to either modify them, turn them in, or move them out of state. After that deadline, possession is a crime. Washington State did something similar, but even more aggressive. They banned the sale of magazines over 10 rounds back in 2022, but now in 2026, they're adding a possession ban with no grandfathering. That means if you live in Washington and you own standard capacity magazines, you have 90 days from when the law takes effect to get rid of them. No compensation, no buyback. Just comply or face criminal charges. Let me explain why this matters even if you don't live in those states. If you travel through these states with magazines over the capacity limit, you're committing a crime. I'm not talking about concealed carrying with them. I'm talking about just having them in your car, even if they're unloaded and locked in a case. Let's say you're driving from Idaho to visit family in Oregon. You pass through Washington State on Interstate 90. You've got a range bag in your trunk with 4 17-round Glock magazines, completely normal if you're from a free state. But the moment you cross into Washington, you're in possession of prohibited items. If you get pulled over for speeding and the officer asks to search your vehicle for any reason, and they find those magazines, you're getting arrested. Each magazine over capacity can be charged separately. 4 magazines equals 4 counts. In Washington, that's a gross misdemeanor per count, which means up to 364 days in jail and a $5,000 fine per magazine. Do the math on that. Now, this is the part nobody's talking about. Several of these states are coordinating with each other. There's talk of a West Coast coalition between California, Oregon, and Washington, where they'll share information about gun owners and magazine purchases. If you bought magazines online and had them shipped to your address, they might have a record of it. And they're discussing proactive enforcement, which means they could come knocking on your door, asking to inspect your property. Is that constitutional? Probably not. Will they try it anyway? Some local jurisdictions already are. You need to know this is happening so you can make informed decisions about what you own and where you store it. Fourth major change, and this one's flying under the radar. Red flag laws are expanding and the standards for issuing orders are getting lower. 19 states now have red flag laws, but in 2026, 4 of those states loosened the requirements for who can petition for an order. It used to be that only family members or law enforcement could file a petition. Now, in states like California and New Mexico, co-workers, roommates, school administrators, and even healthcare workers can file a petition to have your guns taken away. And here's the scary part. The standard of evidence needed is incredibly low. The person filing doesn't need proof that you committed a crime. They don't even need proof that you threatened anyone. They just need to convince a judge that you might be a danger to yourself or others in the future. That's it. One bad breakup, one argument at work, one concerned neighbor who doesn't like that you own guns. Any of those could result in a red flag petition. When a judge issues an ex parte order, that means, without you being present, law enforcement shows up at your door and takes every firearm you own. You don't get a hearing until later, usually 10 to 14 days after your guns are already gone. And during that hearing, you have to prove you're not a danger. The burden of proof flips to you. In civil court, that's a preponderance of the evidence standard, which means 51% likelihood. It's way easier to meet than beyond a reasonable doubt in criminal court. Here's what really concerns me about this trend. There's no penalty for false reports in most of these states. If someone files a bogus red flag petition against you out of spite or revenge, and the judge denies it, that person faces zero consequences. No perjury charges, no civil liability, nothing. So there's no downside to abusing the system. And we're already seeing cases where vindictive ex-partners are using red flag laws as weapons in custody disputes or divorces. What can you do about this? Honestly, not much if you live in a red flag state. The best defense is to maintain good relationships and avoid conflicts that could give someone ammunition to use against you. Document everything if you're going through a divorce or having workplace issues. If you do get red flagged, hire an attorney immediately. Do not go to that hearing alone. You need legal representation to fight the order and get your property back. And whatever you do not violate the order. If a judge says you can't possess firearms and you go to a friend's house to pick them up anyway, you just committed a crime and now you actually will lose your rights permanently. This information could literally save you from losing your rights and your property. Subscribe now because my next video breaks down the 3 things you should never say to police during any gun-related encounter, even if you think you're being helpful. These phrases seem innocent, but they've been used to convict gun owners in court. You need to see that video, click subscribe so you don't miss it. 5th and final change, concealed carry insurance and legal coverage requirements. This one surprised me because it's coming from an unexpected angle. 3 states, Massachusetts, New York, and New Jersey, have introduced or passed legislation requiring concealed carry permit holders to maintain liability insurance. Think of it like car insurance, but for your gun. The stated reason is to ensure victims of gun violence have financial recourse, but here's what it really does. It adds another financial barrier to exercising your Second Amendment rights. Massachusetts is implementing this in stages starting April 2026. If you want to renew your concealed carry permit, you have to show proof of at least $250,000 in liability coverage specific to firearm use. Homeowners insurance doesn't count unless it has a specific rider for firearms liability. And those riders are expensive, usually $500 to $1,000 per year on top of your regular insurance. New York is taking it further. They're requiring $1 million in coverage, and they're limiting which insurance companies can provide it. It has to be a company licensed to operate in New York, which conveniently excludes most of the national concealed carry insurance providers. So you're left with only 2 or 3 options, and they can charge whatever they want because there's no competition. Here's the part that gets really messy. What happens if you have a defensive gun use in one of these states and you don't have the required insurance? Even if the shooting is completely justified, even if you're cleared criminally, you could face administrative penalties for not having insurance. That might include revocation of your permit, fines, or even misdemeanor charges for permit violations. So you defend yourself legally, but then you get punished anyway for a paperwork issue. Let me give you a scenario that shows how insane this is. You're a New York permit holder. You maintain your $1 million insurance policy. You pay your $1,200 a year. One day, you're forced to defend yourself from an attacker. Clear-cut self-defense. The district attorney declines to prosecute. But your insurance company decides not to cover the incident because of some technicality in the policy language. Maybe they claim you didn't retreat when you could have, even though New York has a stand-your-ground law in your home. Now you're facing a civil lawsuit from the attacker's family without insurance coverage, and the state is threatening to revoke your permit for not maintaining coverage, even though you did have a policy, and it was the insurance company that denied the claim. You did everything right, and you still get destroyed, legally and financially. But here's the crazy part. These insurance requirements are being challenged in federal court right now. Second Amendment advocates argue it's an unconstitutional poll tax on a fundamental right, and they're probably correct. The Supreme Court has said you can't put financial barriers on constitutional rights, but these cases take years to work through the courts. In the meantime, if you live in one of these states, you either comply and pay up or you lose your permit. There's no good option. What should you do if you're in a state considering this kind of law? First, get involved politically. Contact your representatives. Show up to public hearings. These laws pass because gun owners stay silent. Second, if the law passes, shop around for coverage. Don't just accept the first quote. Some companies are offering policies specifically designed to meet these state requirements at lower costs. Third, document everything. Keep proof of coverage with you whenever you carry. If a law enforcement officer asks, you need to be able to show it immediately. All right, let's wrap this up. These 5 changes, the interstate reciprocity mess, the expanded sensitive places restrictions, the spreading magazine bans, the looser red flag law standards, and the new insurance requirements are all active right now in 2026. And here's the thing. Most concealed carry holders have no idea these changes happened. They're carrying the same way they did last year, following rules that don't exist anymore, and they're one traffic stop away from felony charges. Don't let that be you. Do yourself a favor. Take 30 minutes today and research the current laws in your state and any state you plan to visit. It's not fun. It's not exciting. But it could save you from prison and losing your rights forever. And look, I get it. Gun laws are boring and confusing. That's why I make these videos. I spend hours digging through legal documents and court cases, so you don't have to. But I can only help you if you're subscribed. Hit that button right now and join over 70,000 gun owners who get these updates first. Don't wait until you're in handcuffs wishing you'd stayed informed. One more thing before you go, none of this is legal advice. I'm not a lawyer. This is educational information to make you aware of changes in the law. For your specific situation, always consult with a qualified attorney in your state. Stay safe out there, know your laws, and carry responsibly. I'll see you in the next video.